Ms. Rios, is this a plea with Mr. Andrews?
Yes. Yes.
All right, how you doing, Mr. Andrews?
All right, sir.
Good. I'm gonna let the prosecutor get situated and then we'll get going.
You see a family member on Zoom?
There is no, there had been some people on, but now it is our family of the McBurney Chambers. And Ms. Stallworth, who's an honorary member. Deputy Gordon, I have a wedding here at 4:30. Did I tell you about that? We have a wedding at 4:30. And I did a Rule 22 because someone's bringing in a camera, like that kind of thing. I figured they'd need it. So we might have a little hiccup at like 4:15. It's not a large group, but you're welcome to stay. My guess is you have to, but they'll be happy to see you. But that's our one thing when we're done here. All right.
How did they land on this courtroom for their nuptials?
This guy was a juror.
Oh my goodness.
He's like, hey, would you marry me? And I didn't know he was a juror. He explained, here's the connection. He says, you're probably going to say no. But I was a juror and like, yes.
All the places you could get married.
Yeah, maybe I'll have him sit in the jury box for it too. Relive the agony. Let me know when you're ready. You're ready. Okay. Ms. Rios, you guys ready?
Yes.
Okay, let's get on the record. This is position 11, 25 SC 000719. State versus Calvin Andrews. Mr. Andrews is in court with Ms. Rios. Ms. Smith is here as the prosecutor. And Mr. Andrews, we're going to work through the conversation about a plea, okay?
Yes, sir.
Ms. Smith will put you under oath and then ask you a bunch of questions. They're not trick questions. Answer them truthfully as best you can. And you need to let me or Ms. Rios know if at any point you've got questions of your own. Will you do that?
Yes, sir.
Okay. Ms. Smith?
Yes, Judge, thank you. Mr. Andrews, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Calvin DeWarren Andrews.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
45, 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of this indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Andrews, do you remember being arrested on these charges?
Yes, ma'am.
State is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Ms. Rios, is this negotiated or non-negotiated? Mr. Andrews, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that's recommended by the state up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yeah.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, bless you.
Bless you.
The right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yeah.
Mr. Andrews, has anyone forced or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 000719, how do you plead to count 1, possession of crack cocaine, and count 2, possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal your guilty plea conviction? But if you believe that there's been some type of error in your guilty plea, that you can apply to the appropriate appellate court for a discretionary appeal?
Yes, ma'am.
Do you understand that that process needs to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Andrews. Your Honor, if this case were to proceed to trial, the state would show that on February 7th, 2024, Sergeant Hallman, that's Holleman of the Atlanta Police Department, was patrolling in the Winchester Street area, that's in Atlanta, Georgia, and also in Fulton County, when he saw a car that had a large windshield crack, and also the person that was driving the car had their seatbelt behind their back instead of across their chest as it should be. Because of this, the officer initiated a traffic stop. When he initiated that traffic stop, he did smell marijuana coming from the vehicle. The person that was driving was identified as the defendant, Mr. Andrews. Mr. Andrews told the officer that he did not have any marijuana in the car. However, he did smoke some of the marijuana earlier that day. At that time, the officer then searched the vehicle based on that raw odor of marijuana. On the driver's side of the vehicle, where the windshield meets the roof, the officer was able to locate a suspected crack cocaine bag and also a bag of suspected marijuana. The officers then weighed this narcotics that they found on the digital scale that they had. Inside of that suspected crack cocaine bag that the officers found, there was an estimate 10 smaller bags within that bigger bag of crack cocaine. The officer, in addition, located a razor inside of the bag with the crack cocaine. At this time, the defendant was placed under arrest for having crack cocaine and marijuana, and he was arrested for the charges we have here today. These are the facts of the case regarding the state's recommendation. The state is recommending a sentence of 5 years to serve 1 with the balance probated. We're asking for that 1 year to serve just based. Most of it is based on the defendant's criminal history. The state has a concern of the defendant reoffending again. We believe that there is a high risk of reoffending. We did file a recidivist notice in this case, but that recidivist notice highlights the 2006 and 2008 possession of cocaine charges, convictions that the defendant has. Also, there is a conviction from 2017 for possession of cocaine with the intent to distribute. In this case, the defendant was given 3 years of probation that would have ended around 2020. Just a year after that, when his probation ended, the defendant was arrested for possession of cocaine with the intent to distribute. That case happened in 2021. However, he did plea in 2024, pled guilty to that charge. And then we have the case that we're talking about here today from February 7th, 2024. It does post date that guilty plea he entered into for the possession of cocaine with the intent to distribute. However, the concern here is that even after the defendant was arrested for this case, he was let out on bond, and in July of 2025, the year after, he was picked up again for possession of a controlled 2 substance. Mr. Andrews was in court before, and we asked a question about drug court and why he didn't want to go to drug court. And he stated that his drug abuse is not crack cocaine. He doesn't use it for personal reasons. So because of the history with the possession with the intent to distribute and having the cocaine on other occasions, the state does believe that there is a high risk of reoffending. And because of that, we are asking for 1 year of custodial time with the balance to be on probation. And that is all from it's not all from the state. Regarding those special conditions of probation, the state will be asking for the defendant to complete a drug and alcohol evaluation with treatment if necessary. For there to be a Fourth Amendment waiver, for the defendant to complete 40 hours of community service, for the defendant to be gainfully employed, and for the defendant to not have any drugs that are not prescribed. And that's all from the state.
Got it. Thank you. Ms. Stallworth, I have some information because of the recidivist notice and the repeat offender notice that were filed. Tell me how many total cycles you have, please, and then what the most recent conviction is.
I have 23 cycles total. The most recent is the open case, the 25 PI 006002, the possession of marijuana less than an ounce and possession of a Schedule II. And then, as she stated, currently the case on probation, the 23 SC case. I'm also showing an active warrant out of Morrow for a probation violation. The date of that warrant was March the 10th of 2026.
10 March 26. That's a fresh warrant. Okay. Can you give me that PI number again, the 25 PI, please?
Yes, 25 PI 006002.
Thank you.
You're welcome.
Okay. Sorry, it's slow in opening up here. Oh, you got a bond. Okay. Ms. Rios.
Yes, Your Honor. Mr. Andrews is 45 years old. He's from Georgia. He has 4 children. And yet the youngest ones are 10 and 14, and he's very active in their lives. He takes them to school. He gives them their lunch. He's like the main caretaker when he's at home for these children. And he hasn't seen them since he's been incarcerated for 9 months. He's also on disability for foot damage. This is charged as possession of cocaine. It's not with intent. They're not accusing him of selling. I'm asking for the in custody time to be 9 months. Now he's fine. He said like they can give me additional probation. He has no plans of messing up. He just really wants to be out to see his children and able to be an active dad in their lives. He also indicated that like this wasn't his car. And so we did talk about that and how that possibly would go at trial. So that's why he's entering this plea today. But he's been in custody for 9 months at this time for a possession charge. So that's why I'm asking that whatever probation amount he's fine with, he just wants to be able to get out and see his children. And he was supposed to have his, is it your fiance? On the call, but she's not.
She may have been on. There were some names I didn't recognize that were on a while. Oh, there's an Alexis Pollard.
Yes, sir.
Okay, she's back on.
She might want to speak on his behalf.
Okay, Ms. Pollard, are you able to hear us?
Yes, I'm able to hear you guys.
Okay, are you connected to Mr. Andrews?
I am.
Okay, what do you want to tell us, if anything, about Mr. Andrews?
What she is stating is true. He actually helps me because I work 16 hours a day, 5 days a week. So he's the one that actually get his 2 children, and he's the one that spends time with them. And lately his son has currently been acting out because he hasn't physically been able to interact with him. He does talk to him on a daily basis, but he's so used to interacting with him. And I can say that I am here to help him with anything that he may need to stay out of trouble.
The 2 children, 10 and 14, are they also your children, or they are important in your life?
No, they are my children, my daughter
Okay.
and my son.
Got it. And they are also his children?
They are his children.
I'm sorry, there was a noise in here. They're your kids, but he helps care for them, or you and he
No. I am the biological mother. He is the biological father.
Got it. Okay. Understood. They are your kids jointly. Has Mr. Andrews lived with you the last 10 years?
Within the last 10 years, yes, but within the last 4, I end up losing my house.
Okay.
So we had to split household, but he currently help far as pickup because my son goes to a school that's not in his district, and we actually share the drop off. I drop off and he picks him up and keeps him in the evening for me, being that I work 16 hours a day.
What do you do?
I am a security guard at the airport, and I am also a security guard with Delta Security.
Got it. All right. Well, thank you, Ms. Pollard. Appreciate you getting back on the call.
You're welcome, Your Honor.
Mr. Andrews, what's up with a warrant in Morrow? Does that ring a bell?
Just because I've been locked up for 9 months, and it's a driving on suspended license, and I have to pay them like every month, and then since I've been locked up, I haven't been there.
You haven't been paying. Okay. You've got 4 kids. I've heard about 2. The 2 that stay with you and Ms. Pollard. Are the other kids younger or older?
They grown.
They're adults. Are they in the Atlanta area?
They not in the Atlanta area.
Okay. Ms. Rios said that you get disability, something about your foot. What's this?
I have nerve damage in my leg. Like my toe, I can't move my toe.
Okay. Is it difficult for you to stand, or are you okay?
I'm all right.
Are you able to do some work or no work?
I'm able to do some work. It'd be a little difficult. I'm able to do some work though.
What kind of work do you do?
I like work at like a little grocery store. You know what I'm saying?
Okay.
Like do a little sweeping and stuff.
Okay. Ms. Smith, are you withdrawing the recidivist notice for purposes of this plea?
I am, Your Honor.
Ms. Simpson, is Mr. Andrews on probation in another case, but this incident happened before the plea, or where are we?
So the PI case, put him in violation. This case did not. The
Okay.
PI case did, and he's already been revoked for Judge Robert in November.
For the PI case?
Yes.
Okay, got it. That's the marijuana with the co-defendant. All right, so I guess he's caught up, if that's the right term. And Mr. Andrews, I guess we talked about this before because it was the first thing I wanted to talk about this time. You've thought about drug court, and you don't think drug court is something you need because you don't use this cocaine that you keep getting arrested with?
No, sir.
You sell it.
I used to.
You used to sell it. Okay, you don't sell it anymore.
No, sir.
All right. Were you the only person in the car with the cracked windshield at the time you got arrested?
Yes, sir.
All right. Anything you want to add?
No, sir.
Okay. Well, Mr. Andrews, I find there's a factual basis for your plea. I'll accept it. Find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to enter this plea. Ms. Rios, can someone, my office sign the indictment for you?
Yes, sir.
Ms. Smith?
Yes, Judge.
And Mr. Andrews, can we put your name on the indictment indicating your guilty plea?
Yes, sir.
All right. I am going to sentence you on count 1 to 5 years to serve 1 year with the balance on probation, and count 2 will be 12 months to serve to run concurrently with count 1. You will get credit for all the time you've been in, not just now, you were in before, and then you got a bond, then you got arrested again, but all the time you've been in since February 7th of 2024, you get credit for. So you're not going down the road. You've got a little bit of time left here in the county jail. Special condition of probation number 1. Where is home? When you are out and you're going to be with Miss Pollard, is that in Fulton County or a different county?
No, just in Atlanta.
It's in Atlanta?
Yes, sir.
But is it in DeKalb or is it in Fulton?
Fort.
Okay. All right. You're gonna, once you get out, while you're on probation, you're already on probation, but new conditions for this case. 1 will be within the first 2 months, you have to sit for a drug and alcohol abuse evaluation. And if that evaluator says that you would benefit from some treatment, whatever that treatment is becomes part of your probation. Number 2, you're going to have a Fourth Amendment waiver, meaning probation can search you if they feel like they need to, or your car, or whatever you got. And 3, you will need to complete within the first 6 months of probation, 40 hours of community service. But you can work with probation on what that is. I don't mean for it to be difficult for you because of your foot condition. There are lots of different ways to do community service. Doesn't mean walking by the road, picking up trash. There are other ways to do it. And I encourage you to do something that is most comfortable for you.
Yes, sir.
So I think that's the right outcome, given the criminal history. And you actually can go deal with Morrow now and be getting credit on your sentence. Because you weren't going to leave, even if I said time served. That warrant for Morrow means we got to get you down there so you can deal with that. Okay?
Yes, sir.
The sentence that I imposed is a little higher than what Ms. Rios asked for. And so you should talk with her because you can say no, thank you. If you want to instead go to trial, we can put you on the trial calendar that's coming up in the next month or so. If you want to do that, or you can decide, hey, this closes this case out. It's not exactly what I wanted, but I'll take it. So why don't you talk with Ms. Rios and then let me know what you want to do. Okay?
All right.
Okay.